This meeting is now being recorded.
Welcome, everyone, and good afternoon. My name is David Cohane, and I chair the Intellectual Property Department at Schotz, and I'm also a member of our litigation department. I'm here today with my colleague, Nicole McDonough, who also works in both our IP and litigation departments. I'm happy to welcome you to the first in a three-part series of our webinars that our firm is offering with the title Intellectual Property 101. As the title suggests, our series is meant as a basic introduction to intellectual property law, focusing on what business people need to know. In today's presentation, Nicole and I will focus on identifying your business's intellectual property assets. Our second and third webinars will be presented in the coming months. The second in our series will address how to protect your brands, content, and inventions, and our third installment will address risk prevention, staying out of court and out of trouble. Our presentations will be recorded and will be made available later for others to listen or, of course, for you to listen again if you're so inclined. We expect to speak for about 30 minutes and will then have some time for questions. Please use the Q&A section on the navigation bar at the top of your screen for questions and answers. You can, of course, type in a question at any time in the course of the presentation. But we expect we'll be probably taking the questions, answering the questions at the conclusion of the presentation. Of course, if any questions occur to you later, feel free to email us or call us. Our contact information is available on the final slide and also through the firm's website. So without further ado, let's get started. We're going to talk briefly today about four categories of intellectual property: trademarks, copyrights, patents, and trade secrets. There are some related fields that sometimes people associate with intellectual property law. Perhaps the most common is the right of publicity, which is the right to control how one's name or likeness is used for commercial purposes. We don't plan to discuss that today, but would be happy to do so offline or perhaps in a future talk. So I'd like to now introduce Nicole to talk about trademarks.
Thank you, David. I'm happy to be here with you all today. I'm going to start my conversation about trademarks and discussing what we've all probably seen in the local grocery store, perhaps in a commercial online. We've all seen that little TM or the R in a circle at the end of a product name. What does that mean? What does the TM mean, trademark? What does the R mean, registered? These symbols signify that the preceding word or words are a trademark. Now, what exactly is a trademark? A trademark can be a word, it can be a symbol, a phrase, or perhaps just a design. A trademark distinguishes one person's goods or services from those of another. And the goal of trademark law and trademarks in general is to prevent confusion in the marketplace and to protect the goodwill of the owner of a specific mark. A trademark is essentially a brand, regardless of whether it's a word or a logo, whether you have the word Nabisco or the triangular sign which contains its logo. It could be a package design. It could be a combination of sounds. I like to think of the NBC sound or the Intel sound, which we'll get into a little later on in the presentation. Trademarks are given protection because they are source identifiers. And as I said, it's essentially to protect consumers like you or I in the marketplace from being confused about whether a specific good or a specific service that has a similar mark is also belonging to a particular owner. And as an owner of a trademark, that matters to you because you do not want another person in the marketplace who may have a confusingly similar mark to yours infringing on your goodwill that you've maybe built up over the course of years. You don't want someone with an inferior product coming in and eating away at that goodwill that took you so very long to build. You've gained the consumer's confidence, and if they've bought your goods in the past or your services in the past and they contained that mark, they were happy, they know that if they see your mark on products again, they'll likely be happy again. So one of the things we like to say is that a trademark is a promise delivered through experience, which is why you want to protect your mark from infringers, to ensure that your brand is not devalued and that your customers remain loyal to your brand. Now, what are some examples of trademarks? On this slide here, I've shown you just a few words and logos. Now you see I have for both Amazon and Apple, I have the Amazon logo, which I'm sure many of you recognize from Amazon.com, and I have Amazon just the word. Both are protectable as trademarks. Why? Because Amazon, as you know, is an online marketplace. It is not, this logo here does not refer to the Amazon River. It's not descriptive. It's not just describing that trademark, and so this particular use of Amazon has become known in the marketplace as an online retailer or an online marketplace where consumers can visit to purchase products. And it doesn't matter whether it's just the word itself, Amazon, in the plain capital, plain text as they call it, or if it's the stylized Amazon containing the arrow and a lowercase font. Same goes for Apple. You see that logo, and we no longer think, especially with the iPhone 7's recent arrival on the market, we no longer think that when we see that apple with a bite taken out of it, oh, that must be an apple orchard. No, we think that's a computer, that's an iPhone, that's an iMac, some sort of iDevice. And that's thanks to the goodwill that the company Apple has built up over decades, frankly. And we don't even need to see the word Apple. Just seeing that logo right there signifies to consumers that this is an Apple product, and the brand that I've come to know and trust is putting their name behind this product, and that's really the power of your mark. Same thing there, that we have the check mark. I call it a check mark, although I'm sure many people know it's the Nike swoosh. And it doesn't even need to say Nike. It doesn't need to say just do it. We know that that's what it means. We see that on a clothing label, and we believe and associate that this is a Nike product. And if you've purchased Nike products in the past, you think, oh, and you were happy with it, you'll be happy to purchase it again this time. Another logo, a very familiar one, the Golden Arches, McDonald's logo. And it doesn't matter, I'm sure everyone is aware, the McDonald's logo has changed over time, and this is something that businesses do to adapt in the marketplace. However, the trademark remains. As long as the company continues to use that mark, and David will speak to this a little later on in the presentation about the value of your asset, as long as you continue to use that mark in the marketplace and ensure that consumers know your product by that mark, you will continue to have the protection associated with that trademark. Now, additionally, not just the stylized words, not just the plain words, you can have protection for a particular color of your product, or this bottle on the right-hand side, this image. I think I probably don't need to tell anyone that that is a Coca-Cola bottle. The trade dress that Coca-Cola has with that bottle is protected, and it's protectable because of the fact that Coca-Cola has used it over a number of years, and it's not functional. That's one of the things that trademark law will look to when you have something like a pink insulation, which we have here with the Owens Corning insulation, or the Coca-Cola bottle. If Coca-Cola were to have said early on in their use of this bottle, we're using this bottle because its style enables the consumer to hold it more easily, or perhaps Coca-Cola could have said something to the effect of, it keeps the soda inside colder. Well, then that would have been a mistake for Coca-Cola, because they would have been admitting or acknowledging, I should say, that the bottle served a functional purpose. Coca-Cola never did that, and that is why they have this protection in the marketplace for the trade dress of the Coca-Cola bottle. And that is why we don't see Pepsi in this exact same bottle as well, because if Pepsi were to try to market and produce their product in this bottle, Coca-Cola would certainly commence a lawsuit claiming that there had been some type of infringement because this is the Coca-Cola trade dress. Additionally, with the pink insulation for Owens Corning, now these things, color is not something inherently that you can get a trademark for just by virtue of its use. Some products are made in that color. So, for example, insulation, however, is not. Insulation, the natural color in the process is a yellow or a tan color. Owens Corning went through great lengths to to ensure and dye that their insulation was pink. They licensed the use of the Pink Panther to go along with their pink color, and they've vehemently and vigorously, I should say, protected their mark for pink insulation in the marketplace. Again, the pink is not a product of functionality. However, no other insulation can be pink, and Owens Corning has protected it, as I said, through lawsuits and infringement actions to ensure that no one else takes away from their goodwill. In this industry, roofing and other home improvements where the use of insulation is needed, people come to rely on the color of that insulation as a symbol in the brand, really. You don't even need to see the Owens Corning name. You simply see pink insulation on the shelf, and you know, oh, that's the Owens Corning insulation, and people will purchase it as a result. Again, that's the brand loyalty that goes along with intellectual property law and trademark law specifically, and why people want to protect that in the marketplace. Another example of a trademark are sounds and scents. Scents, S-C-E-N-T, smells. Now, these are certainly more difficult to obtain protection for. However, the same rules apply. Does this smell or scent or this sound indicate or symbolize the origin of a product? So, for example, the MGM lion, which we have on the first graphic here on the side of the screen, you hear that lion roar, you don't even need to be looking at the television, and you know that that's an MGM movie that you're about to watch. Intel chimes, you hear them, bum, 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 bum. You're like, oh, that's Intel. My computer has an Intel processor. And again, the companies go through great lengths to protect these and ensure that someone like Apple cannot also have that sound when you start up the computer. Why? Because Intel doesn't have the ability to ensure that the Apple processors meet the standards, the same standards as an Intel processor. So whether you think that's an inferior or superior process, the fact remains that when you don't have control over, when you do not have control over another owner's use of your mark, you really need to protect your mark and ensure that they are not using it, because whether they're taking away from your goodwill or confusing the consumers in the marketplace, that's something you want to avoid. Same thing goes for, ironically, in preparing for this presentation, I was trying to see some of the more interesting sounds, and the Pillsbury Doughboys laugh, that's even a registered trademark. You put a little stomach and he goes, hoo-hoo. And again, that's the same thing. It's brand recognition, and that's why these companies, they think about what makes our product unique in the marketplace. How do consumers think about us? And I certainly am thinking about the Pillsbury Doughboy. I think of the little laugh, maybe from childhood or a later time. Speaking of childhood, the Play-Doh. Play-Doh, the for Play-Doh, because it has acquired distinctiveness over time, is also protectable as a trademark. Again, people must come to associate your scent with your product before it could possibly become protectable. So perhaps you have something, a scent or a sound that is unique to your business that you've used over a period of time. And again, that is protectable. That is something that is valuable to your business. So it need not just be a word, it need not just be a logo. There are a number of other things, color, scent, sound, shape of the bottle, that could also apply. And I'm going to, at this point, turn the presentation back over to David to discuss another form of intellectual property.
Which, as you can see on your screen, I'm going to talk about copyright. So copyright protection is available to original works of authorship that are fixed in any tangible medium of expression. That's a mouthful, but I'm quoting from a statute, so I can't help it. But so I'll say it again. Original works of authorship fixed in a tangible medium of expression. Now, the word authorship is a little bit misleading. We tend to associate authorship with text, the written word. And, of course, copyright protection is available for the written word, but it's also available, can be authored by, the authorship can apply to music, it can apply to painting or sculpture, it can apply to film, software, even architectural works. It's a legal protection for an expression that is independently created and fixed in one of these tangible mediums. So what you see on your screen got a lot of publicity over the last couple of years. There was it used to be a little-known fact that the Happy Birthday song that we all sing every time there's a birthday was copyright protected, and the copyright protection was claimed by a particular company that over the years, when it could, collected royalties from people who used those that song. And there was recently a class action that challenged the ownership of that copyright and ultimately won. So you may or may not have seen it. There was ultimately a ruling that the person who had been claiming the copyright and collecting royalties for years did not, in fact, own a copyright in Happy Birthday to You, and after years of litigation, a settlement ensued. So we put up here the what's protectable by copyright, and I've just shown some examples of the original types of works of authorship that can be subject to copyright protection. Now, copyright protection is actually, it would be very unusual for a business not to have copyrighted material, copyrighted works that are protectable, because you don't need much originality to have copyright protection in a work of authorship. So, for example, every time you write a memo to someone else or sketch out a picture to someone else or something like that, you potentially have a copyright protectable work. Of course, most of those have no real value, and we'll touch on that a little bit toward the end of our presentation. But here's a number of examples: books, fairly famous set of pictures by Andy Warhol of Marilyn Monroe. There's a picture of some jewelry here. The comic strip film, of course, is represented here, a very famous picture taken by Alfred Eisenstadt on Victory in Japan Day of the sailor and woman in Times Square. What's important to know here is that to be protectable, you don't need much originality. Only a modicum of originality will suffice. And when one owns a copyright, and the ownership of the copyright is typically invested in the person who creates it originally, unless it's sold or assigned to someone else. In the case of a company, if there's an employee who's working for the company who creates the work in the course of their employment, the company is considered the author. So, as I said, a business is always creating things of one kind or another, often the written word or something else, and often there's copyright protection that may or may not be valuable that adheres in those created works. The exclusive rights that are reserved to a copyright owner are the right to reproduce, meaning to copy the work, to distribute the work, to perform the work publicly, to display the work, and to prepare derivative works from the original. So, for example, a derivative work would be a translation of a book. A translation that's based on the original book would be considered a derivative work. All right, let me move on briefly to patents. What is a patent? We've pictured here the drawing for the original Thomas A. Edison electric lamp, now known commonly, of course, as the light bulb. And this was the drawing for the patent that Thomas Edison was issued on the light bulb. What does a patent protect? A patent protects an inventor's ability to keep others from making, using, selling, or importing the same invention for a set period of time. Now, there's actually three kinds of patents. Of course, the light bulb is an example of the kind of patent that we most normally think of. When we talk about patent, we're often really referring to what's known as a utility patent for a useful device. But there are two other kinds of patents as well, design patents and for plants. I'm not going to talk much about plants. When I say plants, I'm not talking about industrial facilities. I'm talking about things that grow in the ground. So I'm not going to talk much about those, but of course, if anybody has that type of business, get in touch with us and we'll talk further. But normally, most often when people talk about patents, they're talking about utility patents. The utility patent can protect a new and useful process, machine, manufacture, or composition of matter, and any new and useful improvement thereof. Let me do that again. Utility patents cover new and useful processes, machines, manufactures, or composition of matters, and improvements thereon. Those are usually thought of as tangible things and great advances like the light bulb, but they can also include less obvious inventions like, under some circumstances, software and methods of doing business. They do not protect abstract ideas, and there's been all kinds of confusion in case law recently about trying to distinguish methods of doing business and software from abstract ideas. That's way beyond the scope of what we're going to talk about today. But what you should know as a business owner is new inventions, novel inventions, even that our way of doing business or software might be eligible for patent protection. The conditions for obtaining a utility patent are that the invention is novel, meaning it hasn't been done before, and it's not obvious, meaning it's not an obvious extension of what has been done before. And then there's a number of other potential disqualifying conditions. So, for example, it's important to know that if you have an invention, once you start selling it, within a year after the time you started selling it under United States law, you lose the ability to apply for a patent. And actually, under the laws of some other countries, if you sell it at all before you've applied for the patent, you lose the potential for patent protection. It's also, we've switched slides here. What you're seeing here is what patents now look like when they're issued by the United States government. This is the cover page of one of the patents on the iPhone. We haven't given you the whole patent, but just wanted to show an example of what a patent looks like. And unlike copyrights and trademarks and trade secrets, which Nicole will talk about in a moment, patents are issued by the government. You have to apply to the government to get a patent, and you don't have any protection in the patent realm until you get it from the government. The government does register copyrights and trademarks, and that will be the subject of our next seminar or webinar. But it's important to know that you can have a trademark and you can have a copyright without getting it from the government, but that's not the case with a patent. Just briefly, I want to touch on the design patents. Design patents protect the way an article looks, and it often seems to overlap with copyright protection, but as I think that Nicole mentioned with respect to trademarks, copyrights also do not protect functional articles, and that's where design patents can come in. So if you've got a beautiful design of a functional article like a door handle or a telephone potentially, you may want to consider design patent protection either in lieu of or in addition to copyright protection. So let me switch back to Nicole to talk about trade secrets.
Thank you, David. What is a trade secret? I have a few graphics here. Let's start with just generally an understanding of trade secrets. Trade secrets can be anything from a formula, a recipe, a method, a technique, a procedure, or a particular process or plan, but it has to be something that is not generally known to the public and that gives the owner of that trade secret a competitive edge or some sort of market advantage. More specifically, it must provide some value to the owner. So, for example, the first picture, the top left here, is some people may recognize it. I included the baseballs there to add a little more context, is Lena Blackburn's baseball rubbing mud. We're here in Hackensack, New Jersey right now, and this mud is actually from New Jersey, and it has been for over 75 years. And for that period of time, this mud is used by every Major League Baseball and minor league baseball team to de-slick the baseballs. As I'm sure most people know, you touch a new baseball, it's very slick, so you rub this mud on it from New Jersey mixed with other stuff that we don't really know what's in there. Why? Because Lena Blackburn has made sure to maintain the confidentiality of this particular recipe for mud, essentially. And, you know, it's not something that is shared out in the open with anyone. This is something that is protected by the company, and so it in turn receives a specific level of protection out there in the marketplace. So important to the protection afforded to trade secrets is that the owner of that trade secret holds it out as a trade secret. Now, to the extent, of course, you must share this trade secret, whether it's the recipe for the baseball rubbing mud or the recipe for the Big Mac sauce, you have to obviously share it with some people, perhaps your manufacturers, your employees. Then it is important that you enter into appropriate confidentiality agreements to communicate to the person who is assisting you in the preparation of your particular product, of the need to maintain the secrecy of the shared information. Also here in terms of recipes and combinations, we have the Coca-Cola recipe. We all see now on the can of Coke what is in there, but the exact way to combine it and mix it, these natural flavors are just unknown, and this recipe for Coca-Cola is arguably one of the most protected trade secrets of all time. Now, it need not just be a recipe here, Mac sauce, Coca-Cola, mud, but also the New York Times bestseller list. It's obviously a very important title that is given to books, and an honor, frankly, to be included on the New York Times bestseller list, but it's always a mystery, and the New York Times refuses to share how it determines which books end up on the various bestseller lists that they publish. And, that's why that it is protected as a trade secret. Again, it goes to the fact that these companies are holding out their products as a trade secret and protecting this from just falling into the general population, the combination of these materials. Because if a company did do that, then it would lose its protection in the marketplace. Again, why do you maintain trade secrets as with any form of intellectual property? Because it adds value to your business. It makes your business more valuable when you have a product or a recipe or some sort of technique that is unique to your business and other people do not know. The general population does not know how you create it. So that is why people maintain trade secrets, and that is why they're given protection in the marketplace. Now, part of our presentation today is to determine how do you, the listener, identify your intellectual property assets. We've given you a number of examples in the various areas of intellectual property that we've touched on today. But how do you relate to these companies or these works that we've described here for you today? Is it only big companies that have intellectual property? Absolutely not. Every single company has intellectual property assets. Whether you're big like McDonald's or small, a local company in Fairfield, New Jersey perhaps, or you're a public company or a private company, or you're a nonprofit, you all have certain brands that you're known by, certain aspects of your business that are unique to you, certain inventions that you've created all on your own, strictly for your business. So you need to ask yourself, what intangibles are adding value to your business right now? What specific symbols? Are there words? Are there logos? Do you have a catchphrase that you're known by? How do your customers and your potential customers to whom you're advertising think of you? What do you want them to associate with your company? Additionally, you could ask yourself, what original works have you created that other people may find valuable? And on that same line, what have you invented that is new that would be valuable to you if only you could make or sell it? These are the questions that will help you to identify your intellectual property assets, and then taking the next step to properly protect them. On the issue of trade secrets, again, what knowledge do you have or use in your business that other people just don't know? So these are some questions to ask yourself in thinking about whether you have intellectual property assets. I'm willing to bet that you do. And then the next step, how do you properly protect them? So let's move on to the next slide. David is going to discuss the value of those assets. Maybe you're thinking, oh, I think I have a logo that I'm known by, but I don't think it's valuable. Think again. David?
So just to close our brief presentation today, I want to talk a little bit about assessing the value of your IP assets. And I'm not talking here about formally putting a dollar value on your intellectual property assets, although one can do that when one needs to. But what I'm talking about is determining which intellectual property you should pursue protecting. And you really need, every business needs to do this on a case-by-case basis for itself. I mean, who would have thought that Post-its would have been so valuable? Some people didn't, and finally someone realized it was a good idea, and look how it's taken off. So we just put together some questions that, again, you might ask yourself in trying to determine which intellectual property assets that you own are worth spending some time and potentially money trying to protect. And I think the first question to ask yourself is, what makes your business uniquely yours? Or to say it a little bit differently, what sets you apart from others? What would be most costly to you if someone else used or copied it? If the heart of your business depends on people associating your product or service with you, particularly because they know that you are do that service or produce that product better than anyone else, you want your trademark or service mark to be protected, because it's what makes people come to you and buy from you. What would be most costly to you if someone else used or copied it? Again, if someone used your trademark without your permission, that could be extremely damaging to your business. What if someone copied a piece of artwork that you were selling? You might have a poster that you've created that is an important part of the business, or a photograph that you have taken that you sell to a lot of other people. Obviously, photographers obviously sometimes make their money by selling works that they have created, and sculptors and authors and filmmakers and architects all can say the same thing. If you would be upset that someone copied it because it's of value to your business, that's a way of identifying that you've got a valuable IP asset. And I often ask people who come to me, should I bother pursuing protection for such and such a piece of intellectual property? Well, would you be upset? Would you feel like someone was making money off of you when they shouldn't be if they copied or were using this particular trademark or copyrighted work? Similarly, if you have an invention that you've either patented or which you've kept secret, and either someone is practicing that patented invention, or an employee or someone in whom you've reposed confidence is using that trade secret or patented invention without your permission, you are entitled to compensation for that and or to stop them from doing so. But all of these things, all of these examples of intellectual property are only as valuable as you make it. You have to be able to identify it. You have to be able to take appropriate steps to protect it and keep others from using it. Are others already using or seeking to use your intellectual property? That tends to indicate that they think it has value and would potentially be prepared to pay for it either voluntarily or involuntarily. So this is a perfect segue to our next presentation on how to protect your intellectual property. And so we invite you all to join that, and we'll be putting out a notification when that will be in the next month or so, and certainly invite others to do so. So that concludes the presentation. I'm trying to see if there's any questions from the group at this point. I don't see any, but we can hang around for a few minutes to see if any questions pop up, and obviously feel free to give either Nicole or myself a call or send us an email if you have any questions. So thank you all for joining us, and as I said, we'll hang out for a few minutes to see if any questions arise. So we had a question about, really it goes to copyright, And if you have many paintings, is it cost prohibitive to protect those paintings? So the first thing I'll say is, and I alluded to it earlier, you have copyright protection in the paintings as soon as they are painted by you, but it is potentially important to register those with the United States Copyright Office because although your copyright protection isn't given to you by the government, you can't sue anyone for infringing your copyright until you have registered it with the Copyright Office, and there's certain other advantages that that you get from registering before an infringement begins. The actual process of registering a copyright is not expensive, and actually the Copyright Office puts out a number of publications on how to do it. I've often walked clients through it, and if they have many copyrighted works, they sometimes do it themselves, unlike trademarks, which I rarely recommend people do on their own. But the registration fee, I think, is now $50 per work with the Copyright Office, and there are ways to register works collectively under some circumstances. It would be, I'd have to extend the remarks too long to go into detail on that now, but for example, if you put out a catalog with your paintings in it, that's a way to register multiple works collectively. So there are ways to do it, quote unquote, relatively on the cheap, and I hope that answers that question. See if there's any others. All right, hearing no others, we will bring the session to a close. Thank you all again for joining us, and we hope to see you at the next one. There is another one. Question, I guess the follow-up from the last question. The question is, I don't know if everyone sees them or not, so I'll just read it. I've got a new startup. Is there a specific way to protect? Again, the registration process is with the United States Copyright Office. It's at copyright.gov. And if you go there, you'll see they have a number of publications going to how to register a text, how to register a painting or piece of artwork, how to register music. In terms of a startup, I'm not sure if we're crossing into territory of whether you want to be incorporated or form an LLC or some other mechanism that's really more on the corporate side than on the intellectual property side. But whether you're a startup or an established business, the methods of registration for copyright are essentially the same. All right, thank you all, and we look forward to seeing you, quote unquote, next time. Thank you.